All right, hello everyone. Good morning. Thank you all for showing up. Hopefully everyone is not too zoomed out of meetings yet. I think we'll start going back to in person probably soon. But for those of you who don't know me, my name is Justin Stivers. I'm an attorney, own the probate law firm here in Miami, and thank you, Lena, Elizabeth, for having me again. I've spoken in front of your group before, mostly on probate. This one, I kind of wanted to mix it up a little bit and talk a little bit more about the planning side of things, how to prevent probate, and how that is important for you all, both on an individual side and kind of on just your business side when you're speaking to clients. So I started doing a seminar called Legacy Wealth Planning. This is admittedly kind of the first one I've done specifically for realtors. I'm trying to do a condensed version, so we'll see how it goes. But if you all have questions, if you all want to, let's make it as interactive as possible. I've got some highlights to kind of go over. I've got about 45 minutes that I can, 30 minutes for the presentation more or less, and then I can stick around for 10 minutes or so to answer any questions, and then we're going to record this and just make sure you register, and then I'll email you all the link after. So all right, so what I kind of titled this, apart from legacy wealth planning for realtors, is why most estate plans fail and then what to do about it. And so just as kind of like an underlying theme for this call, something to think about, if the worst, and I know it's kind of maybe a depressing topic on a Tuesday morning, but if the worst thing happened to you, tomorrow, what would happen to your family, your assets, and your legacy, right? So that's just kind of something to keep in the back of your mind. So if something happened to you, what would happen to everything that you've accumulated? What would happen to the family? What would happen to your legacy, right? So who you are, what you stand for, your beliefs, all those sort of things. Would that be passed on or not? And so most people come to us for estate planning when they have really six concerns. So there's, we've kind of identified 6 things that I see as kind of the repeat, most common things that people are concerned about. Number one, they want to make sure that their money, their hard-earned money, gets passed on without the government or the courts being involved, right? The second thing is they want to avoid any unnecessary taxes and fees. Taxes, fees, big one. Number 3, they want their dignity in their final years and avoid going broke paying for nursing home costs, right? There's a statistic, I think it's about the average stay in a nursing home in Florida, in Miami, is about $10,000 a month, right? So about $120,000 a year paying, just going to nursing home costs. Number 4, once they've passed on, they want to make sure that their family is protected from creditors, people coming after the money, or another term we say predators, so people taking advantage of people knowing that they came into money. Number 5, probably the most important thing, or one of the most important that people say, is they just want to make sure that their family is not ripped apart fighting over their stuff after they pass on. Right, so that's the fit. They want to make sure that their passing actually brings their family members together. And then lastly, they want to have a way to capture all of their family story, life experiences, wisdom, all that sort of thing. And it's interesting. This is to kind of back up, why I'm doing this type of work specifically. So I've been, and again, for you all that know me, I do a lot of probate. The name of the firm is the Probate Law Firm. We do several hundred a year. And, I've seen just firsthand how awful it is most of the time for people going through the process. As good as I think we are, and as good as, it's not easy for people, whether or not their family gets along great, which 90% of the people say, oh, that would never happen to my family. They get along great. And then they don't get along so great. Even if it's not a full blown out war, there's just friction, right? So it's very, very difficult for people. It takes a long time, which you all as realtors will know that if you're trying to sell a property in probate or purchase a property in probate, it's stressful for you all, right? Because you want to get paid, you're trying to help the family's calling you, there's judges involved, there's attorneys involved. So it's very, it's very difficult. And it's so, the thing is, it's so easy to avoid, right? It's so easy to avoid the probate process with just, very simple, very simple planning. But there's kind of two things where I see a lot of people, why they don't do it, right? The first is just procrastination, right? It's not a fun thing to do. Most of us don't like to think about, we all know we're going to pass away. We know it's inevitable. We just don't really want to think about it. And we're busy, right? I just thank you, some people, everyone congratulating me. If you didn't know, I had a baby girl last week. So I'm busy, right? Life just got extremely, extremely busy. And, you all are busy. You have families, you have work, you have loved ones, all that sort of stuff. It's just, it's an easy thing to put off. So I would say, that's probably one of the main reason why people, I'll get around to it, is what most people say. Or number two, they just don't know enough, or there's a lack of knowledge about it, or there's misinformation. I can't tell you how many people I speak with that will tell me something and I'm like, I don't know where you got that. Like, it's not true. They think one thing specific, let's say real estate, for example. This is extremely common. Someone has a will, they pass away, and the family thinks, oh, hey, mom did a will, she left me the property, that means I get to go put the property in my name. And then they find out a will in Florida doesn't avoid probate, and they got to hire an attorney, and they got to get the will admitted. And that's happens. I get that call every month, multiple times, every single month. And so there's just a lot of information, or you all, I'm sure, can relate, a friend's, I get this call, hey, oh yeah, but I was speaking with my friend and he said his mom went through probate and it was done in 2 weeks, or whatever the case that I just know cannot be true. And so there's a lot of misinformation out there. So it's not really you or people's fault for not knowing. It's just there's a lot of information out there that people aren't necessarily sure about. So that's kind of why they put it off. But there's really two things that I see people do. Number one is they do nothing, right? That's probably, there is a statistic, I don't remember what it is, of how many people do no planning whatsoever. That's probably the majority of people, is they don't put a will in place, they don't put a trust in place, they don't do any of those types of things, just because, again, I'll get around to it. Everyone, you all, I'm sure there's someone on this call who when you saw that this webinar was going to be on wills, your initial thought was, oh, I know I need to do that, right? Everybody whenever I say I do wills or trust, they're like, oh yeah, I've been meaning to do that. And that just, they kind of continue that thought. So they just don't get around to it. So it's probably the most common. And then the second one is, we'll just say cheap or do it yourself stuff. There's a lot of information out there, and I'm not knocking all of it. But, LegalZoom, online stuff, cheap wills. I mean, there's so much stuff out there, right? You all, have seen do-it-yourself deeds, for example, right? They're not all bad, but they don't all work, right? Because sometimes when people do a deed themselves, you would think, you fill in the blanks and maybe the blanks aren't correct, or the deed wasn't for that specific state, or it wasn't recorded properly, or whatever. Same sort of things with wills. Just because, the company advertises it as being, foolproof or whatnot, doesn't mean it's gonna work 100% of the time. And so that's where, I kind of want to talk a little bit about is, and tie it into real estate as well, is, I think the do-it-yourself stuff is almost more dangerous than the not doing anything, because at least if you don't do anything, you've kind of thrown up your hands and you know what's going to happen. It's a free-for-all at that point, you know. But if you do it yourself, you might be under the impression that you're taken care of, or that your things are being taken care of, when in actuality they might not be, and it's too late, by the time you figure that out. So most people, let's say 98% of the people, they want to do a quote unquote simple plan, which usually looks like everything to my spouse when I die, and then when he or she dies, everything to my kids equally. That's probably, everybody wants to do that to some extent, right? There's some people who maybe don't like some of their kids, or they want to leave some money to charity, or, but I would say the majority of people, hey, I want my spouse to be taken care of when I pass away, and I want my kids to be taken care of. That's probably most people. But let's go, going back to those, kind of concerns that a lot of people don't think about, right? If everything goes to your spouse, what happens if that spouse remarries after you pass away, right? So let's just use real estate. Let's say you leave a house, you've got a house, and you and spouse are on that house. Now you pass away, your spouse owns that property 100%. What happens if that spouse remarries? And now him and her, or those spouses, they get divorced. Guess who's getting 50% of that house? That new spouse. And so now what was supposed to go to your kids went to your spouse, which is what you wanted, but now he or she got married, and now 50% of whatever they had is going possibly to somebody else's kids because they got divorced, right? And so a simple will where you just say everything to my spouse and then everything to my kids isn't going to protect you in that situation. Or if you have nothing, it's not going to protect you in that situation. So that's something that we see a lot of. What about kids with creditors, right? Kids with debts. Not all kids are going, and not all people are going to have IRS liens and credit card debts and all of that sort of thing. But, we're all in Miami, the land of Morgan and Rubenstein and all these places where people are getting sued left and right. People get in accidents and get sued all the time, right? So it's possible that you have a fantastic son who, goes to church every Sunday and tithes and does all of these great things, but he gets in an accident, someone gets hurt, and now they're suing him. Well, if you left half of your money to him, those creditors are getting it, right? And so you left, 10, 20, 100, 500,000, whatever it is, they are potentially going to go after that money. And so again, that plan of, hey, let's just leave everything to my kids might not be a good idea, right? What about if the child has substance abuse issues? Do you really want to give a child whatever that amount, X amount of dollars, if you know they're gonna drink it, use drug, whatever it is? Probably not. We probably want to put some sort of safeguards to protect them from themselves, right? And so again, doing nothing or just leaving everything outright to the kids might not be the best idea. This next one is, whenever I mention this one, I always get a lot of interest. Do you like your daughter-in-law, son-in-law? Do you want your son-in-law? Do you trust that they're going to remain married? Do you want to leave all this money to your kid, which you hope will eventually go to your grandkids, only to find out that now your kid's getting divorced and he or she's taking half of the money, right? Probably not, right? Most people, I don't know what my in-laws will say about me. I think they like me, but I think most parents I have found are not always thrilled with the people that their children are dating. There's usually a little, or even if they like them, they're a little concerned. They don't want to, again, all this money that they've accumulated, or the house that they've accumulated, the homes that they have, they might not want they're concerned about their kids getting married and then divorced, and now that spouse taking off with half. Tax benefits, right? So not going too far into tax benefits, but there are some tax benefits with proper planning that can protect your kids from having to pay large inheritance taxes, or from you having to pay large taxes when your spouse passes away. So that's another thing. We talked a little bit about probate and having people avoid going through probate so that there's no fighting, right? Again, I can't tell you how many, every day I see fighting. It's getting, I don't know, it's easy to blame COVID and all these other things, but it's getting worse. Even a lot of stuff that I have that I thought were like, hey, these are really nice people, are turning into not so nice people. And it's not their fault, but it's just, tensions are running high, and families are, fighting over things. And, it's sad to see. So some proper planning, and again, talking about the wills and whatnot, not avoiding probate, just doing a simple will is probably not going to be the best solution to avoid that. And then the last thing that I'll mention to wrap up scaring you all is nursing home costs. And we talked about that a little bit, right? And so, that's an additional layer of protection depending on your circumstances. The last thing most people want is to, save all this money, reach a certain age, and now they get put in a nursing home, and they really don't have any money to leave to anybody because all their money is getting spent just on paying for nursing home costs. And again, in the other slides, I think it's about 80% of just the population in general will have some sort of healthcare, some sort of, whether it's a nursing home, in-home care, some sort of somebody helping you that you're paying, that you might be having to pay out of pocket. So trying to plan and protect for that, right? So what can you do, right? So we've talked about all these things that you don't want to happen. How do you do it? Well, just us specifically, we do something that's called legacy wealth planning. And so all of those things that I mentioned can be avoided. And to just kind of give you some ideas, the spouse that you don't want to that you're concerned, you can set up something so that in your document, in your trust, right? And let me back up just for those who don't know, there's a difference between what's called a trust. Some people refer to this as a revocable trust and a living trust, a bunch of different names. I'm just going to call it a trust to keep it simple, and a will. And the just biggest thing to know here is a trust, if done properly, you have a lot more control over it. It's going to avoid probate. It's private. It's not, everybody doesn't know what's going on, as opposed to when you only have a will. There's courts involved, there's a judge involved, it's public record, everybody can find out about it. So those are the, kind of big differences. But with the trust, you can put in there language that says, hey, husband, wife, we've been married. I want you to have all my money when I pass away. And I want you to get married. I'm fine with you getting, well, some people maybe don't want their spouse to get remarried, but let's assume you're okay with that. I'm okay with that, but I don't want you to get married and then your new spouse take half of my money that I wanted to go to our kids if we get divorced. So we can put language into our trust document, your trust document, that says, hey, if you're going to get remarried, that's fine. But if you want to keep getting money from the trust that I'm leaving you, you have to get a prenup before you get remarried. And so you're kind of forcing that spouse or your spouse, if they get remarried, no issues there. You're having them get a prenup so that the money that you earn that you eventually want to go to your kids is protected from your spouse possibly getting divorced. And this is this is just an option. This is just an idea that we do. But what I like about it is, some people might feel uncomfortable asking for a prenup. But if you know that you're getting X amount of dollars regularly, and that money is going to be cut off if you don't get a prenup, you might be more inclined to do that. So that's an option. Kids with creditors, right? So we talked about people having debts. We can set up for the kids where that money, they still get the money, or they still get the house, or they still get whatever, but it's set up in a separate trust for them. A third party, a family member or somebody else, is going to manage the money for them. And they have the discretion, they have the ability to give that kid money or not give them money. So that way, if you see, and it's the same for drugs and alcohol, if you see, Johnny is suffering from alcohol addiction, well, we don't want to give Johnny $100,000 if we know he's going to go gamble it away and drink it away, or whatever the case is. So we've set up protection for him where somebody else is managing that $100,000 for him. And when they see that Johnny's getting his life together, yeah, we'll give them the money, no issue. Or we'll give them smaller amounts of money. We don't want them to starve to death, but we don't want to give them a huge lump sum. So that's something that we can do. Also, if we're concerned about who they're marrying, who they might be marrying, we can set up, again, a separate trust for the kids, so that that money that's in that trust, if your kid gets divorced, that spouse can't come after that other money, because that money was set aside in trust only for your child and doesn't become part of the marital asset. So when they get divorced, he or she can't go after that money, right? So now your money that you left for your kids is protected for them and ultimately your grandkids, and not going to the ex. So that's another great thing that we can do. Talked about the probate avoidance, where if everything is set up properly, and here's where, for the real estate, it's really important. A trust is only, let's think of a trust as like a treasure chest, right? The trust document is the chest itself. If you don't have anything inside of the chest, inside of the treasure chest, it's worthless. It's just a piece of paper. It's just a box, right? So we got to put assets inside of the trust. So for real estate, for example, if you own a piece of real estate and that real estate is in your name only, I, Justin Stivers, own 123 Main Street. When I die, my heirs, my kids, my wife, whoever is getting that property has to go through probate to put the property into their name so that they can sell it, rent it, live in it, whatever they want to do. If, however, I transfer the property so that my 123 Main Street is now owned by the Justin Stivers Trust, now when I pass away, the person who's in charge of kind of managing all of my affairs has immediate access to that property, and they can sell it, they can rent it, and they don't have to go to court. They don't have to go to probate to do all of that. And so now it's private. Not everybody knows that it's going on. And for you all that market to probate or anything, you probably have bought lists before. You've seen that it's public record. That's not going to happen with a trust because no one knows who owns it. There's more privacy, and you can sell it immediately. You don't, if you're the realtor representing somebody who inherited the property through a trust, you're good to go. If it was done properly, you don't have to go to court or anything. You're able to just sell it immediately. So that's another one of the great benefits. For your clients, that might be something that you talk to them about as kind of like an added value, and say, hey, listen, I don't know if you thought about it, but who do you want to get the property after you pass away? How are some ways that have you thought about that sort of thing? And it's really simple for them to do. And for their homestead property, they don't lose the homestead exemption. You still get the tax benefits. It doesn't count as like a transfer of real estate, so the property doesn't get reassessed for property value. So whatever you own that property since 1950, you're still paying the same property taxes. It doesn't count as like a change of ownership. So you still get all of those great benefits. So that's a really strong incentive for a lot of people to do the trust. Tax benefits, again, if we're doing the trust, most of the population. So Florida is great in the sense that we do not have a state inheritance tax. So some states do, and Florida doesn't. There is a federal inheritance tax, which of right now is $11.2 million, right? The majority of the population don't die with $11.2 million, right? However, that is set to change in 2026 and go down to just over 5 million. Again, substantial amount of money, but a lot more people are going to be affected by that. And so if you have, or you anticipate having, and that's, that could include your house and other things. In Miami, if you had a house in, wherever it was $200,000, it might be worth, $800,000 in the next 2 years, the way things are going. So you could reach that $5 million threshold at some point. And so by putting it into the trust and by doing a trust, there's a lot of things that you can do to limit the liability that your spouse and that your children or your heirs might have when it comes to paying some sort of inheritance taxes. I'll pause right there and see if anyone else. Well, I'll make one more comment on putting things into the trust. So that was the that was the real estate. That was that, you know, but the other things you'll put into the trust are bank accounts. You're going to put stocks, bonds, all of those other things. Because again, think about the treasure chest. That's the trust. Anything that we want to avoid probate and to distribute, we need to put into the trust. So we're going to change title on all of those other assets to make them owned by the trust. So I'll pause right there, see if anyone, you know, wants to throw any questions out.
I will start, I guess. Justin, you mentioned at the beginning about the wills, and so it made me think, so what good is a will anyway if you can't, you know, do the things that you thought you could do with it? So what's the purpose of the will, and is there a purpose?
So there's a purpose when we do our trust for somebody, as part of all of our packages that we do include a will. And the reason is this: if, let's say, we do a trust for somebody and they go buy another property and they don't put that property into the name of the trust, and so now that home is going to have to go through probate in order for it to be transferred to the beneficiary. So we did the trust, but for whatever reason, we didn't put that property into the trust. The will is there to basically say, do what my trust says, right? It's kind of like a catch-all. So we do it as kind of like just an added layer of protection. Hopefully when we do the trust and we do everything, hopefully no probate is necessary. That's the goal. We don't want probate to be necessary. But again, if my client goes and buys another property and they don't title it in the name of the trust, it's in their name only, they forgot to do that, their kids are going to have to go through probate in order to transfer that one asset. So we want to have a will in place so that the will is going to say, do everything that my trust said. So that's why we do it. Now, why would somebody who off the street, random person, just go do a will? Kind of goes back to the beginning, misinformation. Most people who do a will on their own don't know that a will doesn't avoid probate. So is there any reason for it? I don't know. I don't really, you know, I can't think of a great reason for it. At least in Florida, I really can't. You know, I know some other states don't have as lengthy and as difficult as a probate process as Florida. Florida, California, New York, a couple other states are more difficult, but I have colleagues in other states where it's a breeze. It's very simple for them to do it. So maybe it makes sense in that sense. But in Florida, I can't really think of a great reason to do it, other than I think some people just, again, they don't know. And so they do the will and then their kids find out, oh, what was the point of doing that?
Thank you for clarifying that. I kind of wasn't sure about it either. Now you mentioned trust and putting everything in the name of the trust, including bank accounts. So I don't know if this is a more of a banking question or a tax question, but so you would have to go and change the name in your bank accounts and checks and all that, or how does that work?
Yeah, and so one thing I didn't mention is that whenever you put something into a trust, it's still your money, it's still your house. You're not losing any sort of ownership, right? So a lot of people, when they first think about it, it's like, well, why would I go put it in the trust name? That means I don't own it. No, if it's your trust and you're still alive and you put the property into the name of the trust or the bank accounts or all of that, it's still your money. You can, only on paper does it really appear differently, but for all intents and purposes, it's still your money. So what you'll want to do, let's just say that you have a Bank of America account as your primary checking account, right? That primary checking account, most people, it's in their name or a joint account with their spouse, right? And so if one spouse passes away, if husband dies and wife is alive, wife doesn't have to do anything. That money's hers. She can go withdraw it. It's a normal account. But when she dies, now that bank account is locked. And so if the kids want to go get that money out of that Bank of America account, again, they can't go to Bank of America with a will and say, hey, look, this is my mom's money, or my mom left a will, can I get the money? No, they're going to say you have to go through probate. So what you'll want to do is you don't have to change the account to be owned by the trust. But what you would do is you would make the trust the beneficiary of the account. And so now, if let's just say daughter is the person who the parents have named as what we call the trustee, which is the person in charge of kind of doing everything after the parents die. Now daughter will be able to go into Bank of America. She'll say, look, I'm the trustee. The trust is the beneficiary, and Bank of America will honor the trust and release the money to her so she can administer the money however you want it to happen. So we would make, on most all of your accounts, your stocks, even your life insurance. I like to name life insurance. I like to name the trust as the life insurance on the account for a variety of reasons. But let's say that, well, here's why. Let's say that you name your spouse as the beneficiary, okay? And now he or she dies, and now you don't have any beneficiary. So now when you pass away, your kids, again, same thing, can't just go to MetLife or John Hancock or wherever you have a life insurance policy. They're going to say you have to go through probate. So if we name the trust as the beneficiary, those people that you've named as the trustee will get to go into the life insurance policy, collect the money and distribute it to whoever you wanted to. And now they have money to do things. They have that money to distribute it however you wanted to pay off taxes or whatever issues might come up. If you just name a beneficiary on your life insurance policy, once that beneficiary gets that money, that's their money, they're done. So I generally, in most circumstances, like to name the life insurance policy as the trust as the beneficiary on the life insurance policy. But yeah, your stocks, your bonds, your real estate, we're going to make either beneficiaries or owners, the trustee owner.
I would assume IRAs as well, or any kind of retirement
yeah,
accounts.
IRAs are a little bit different just because there are tax consequences, right? You can only withdraw at certain ages, and there's penalty. So depends. I might leave the IRA in the name of the beneficiary, but in certain circumstances, we might name the trust as the beneficiary.
Can a trust name a trust as a beneficiary?
Yes. Yeah, you can do that.
Okay.
Yeah. Now, I might not do that. I don't know that I would because if you name a trust as a beneficiary and then that trust is dissolved or something happens to that trust, then, it's kind of that distribution might be difficult. So we might not, if there's a really good reason, we might do that, but just thinking out loud, I might not do that.
Guys, you can ask questions y pueden preguntar en español porque creo que Justin sabe español o entiende español.
Bueno, yo creo que sí.
Okay, there you go. There you go. Very good. Is Sophia Grace going to be taught both languages?
Oh,
from the get-go?
We want to. My wife's parents Venezuelan, Cuban, and so she grew up speaking Spanish. But me and my wife don't really speak Spanish together. It's super awkward when we try to speak Spanish together. But we would love to, because her dad doesn't speak English. So we'll see. We'll try. But as of right now, I think it would be like an individual thing. Like maybe if I'm out with her, I'll do it, and my wife is out with her, she'll do it. But together, it's really weird for us to speak Spanish together.
Guys, if you have any questions, you mentioned about the remarriage. That's the one I was thinking about. Of course, my husband is not allowed to remarry after I pass away because then the hauntings will begin. But assuming that happens, and I've heard about, and this is not my first marriage. I had a prenup, and people have told me, yeah, that's not worth anything, and that's not really enforceable. And then we see all these celebrities with the prenups, and they go through heck. I know that's not your part, the prenup, but how viable is that? Is that a good option? Is there a better option?
So prenups are tricky, you know, for a couple of reasons. Every legal document can be challenged, right? I mean, you look at Fortune 500 companies that have teams of attorneys working on stuff. They're involved in lawsuits all the time, people challenging contracts. So as good as, you know, or you all maybe from experience, maybe think or don't think that the FAR bar form is great. You would think it's pretty clear, drafted by attorneys, revised by attorneys regularly, ton of litigation, fighting over things in the contract. So there's always the possibility that, you know, even you spend these celebrities that I'm guessing the Kardashians have pretty good attorneys doing pretty solid prenups whenever they get married. But I'm sure there's still challenges to them, right? So there's still the possibility for challenges. In Florida, there's tricky stuff, in part around the homestead property, because the primary residence, because Florida really wants to protect the spousal rights to the homestead property. And so that's sometimes tricky to do prenups around. What you know, if you're on a second, third marriage, or if you've got kid, you know, first marriage, but your spouse has kids from a previous marriage or someone else, you know, I think a prenup is a great idea. Obviously, not everybody, either religious reasons or just discomfort reasons, don't want to do a prenup. That, you know, there's a variety of reasons maybe why someone would not want to do a prenup, which is fine. If that's the case, if you're not going to do a prenup, then I think as part of like this planning process, we want to maybe have the assets titled not in everybody's name jointly, and then have each person have their own trust that kind of says what happens with their stuff, and maybe have each person even sign off on it. It's not a foolproof, 100% foolproof way if after the fact, you know, your spouse is like, oh, I was just tricking him or her, and now I'm coming after all of this. It's still possible. But if you know, when you have, let's say, a Bank of America account, and it's in both of the spouse's name, and one of the spouses dies, it's that other spouse's money, right? Even though you guys, you know, and I hear this all the time. Oh yeah, but me and my spouse have an agreement that money is for my kids, and he's not going to touch it, or she's not going to touch it. I hear that all the time. Well, you know, if spouse wants to keep that checking account and his wife or husband passed away, he doesn't have to give that money to the other kids. Maybe he or she's a really great person and going to honor their wishes, but there's nothing that they can do. So I would say in circumstances like that, you're probably going to want to not have joint owners, and then you're going to want to have some trust in place that say what happens with each specific asset.
Or you just have to outlive your spouse. I think that would be.
Well, you're probably fine. Unfortunately, it seems like us gentlemen seem to be the first to go. So.
So I'm just trying to make light of a really dark.
Yeah, I do it every day. So yeah.
But anyway, I don't know if we have any questions, guys. You know, Justin is here for you. So if you have anything in mind. I know that when we're counseling our buyers and sellers, we want to give them the best advice possible. And so this might be good. I see that Justin put his contact information on here. So please take it down. And we want to counsel them on the best way to take title, to do things. And for you that are dealing with people that are downsizing or retiring, this might be the best conversation you need to have with them before they do that. Leslie, you have a question. Go ahead and unmute yourself.
Yes. Hi, good morning, everybody. I do have a question, and
You have to say yes. You have no choice about that nowadays.
I was
Sorry, go ahead,
saying
Leslie.
that, yeah, I'm sorry. My question is in concrete. Let's say that a couple is been living together with no marriage. How is that taken into consideration? Like, are they considered married, or that would like take away all these marriage? So, I don't know, inheritance. How that works?
Yeah, if you're not married, I'm not saying you, but if a couple is not married, they could be living together 50 years. If they're not legally married, it's as if they, they're not married. So you, the person who passes away, their partner is not going to get anything because they're not family member. And I see that all the time where a couple lives together, they weren't legally married, the first spouse passes away, and now, that's the person who passed away. He's maybe got siblings who come up and they didn't have any relationship to him, and they say, oh, well, he owned the house, so we want the house, even though the partner, the long-term partner, has been living in that house 50 years. If that other spouse or that partner was not on title, he or she doesn't have any rights to anything, and those siblings are going to get whatever there was. So yeah, Florida doesn't have anything like that. If you're not legally married, you don't have any rights to that other person's stuff after they pass.
That's good that you tell me, because I don't know, I was under the impression that after living together for 7 or 10 years, I don't remember who told me, you were considered married. And I was like, what? No.
So go back to minute 5 of my presentation where I said a lot of people have misinformation about stuff. Again, not your fault, but I hear stuff like, I don't know where that's from, right? But it's unfortunately not true. Yeah, if you're not legally married, you don't have any rights to when they pass away. Again, regardless of how long you've been living with them or anything. If you're not on the bank account and you're not on the house, that person's family, their next of kin, is going to get that stuff.
And Justin, I guess maybe that comes from that common law marriage thing in other states. I know some states
Could be, yeah.
have that.
Yeah, some states. I think North Carolina has that. A couple other states have some sort of common law. They've been together, but Florida, unfortunately, no, we don't have that.
So Justin, now that you said North Carolina, so if a person, let's say we're getting a lot of people from up north and they're moving to Florida and they have a property that they're going to keep up north, but they want to do like half a time here, half a time there. And they want to establish their residency here. Now, what happens to those properties? Are they in the trust? Is it all guided by the same laws of the trust? Or does it matter if properties or, any kind of assets are on in a different state?
Yeah, great question. And same for, we'll broaden that to other countries, because obviously we have a lot of foreign investors and people here as well. So if you, and this is really common, let's say North Carolina, New York, or California, wherever people are coming from now, if you come here to Florida and you buy a house in Florida, but you also have another home in a different state, and you didn't put the properties into a trust, you're doing 2 probates. You're doing a probate in Florida, and you're doing a probate wherever you had assets in another state, right? So we do that. It happens all the time. Actually, a lot of times people have second homes in Florida and live in New York. So I get a lot of calls from an attorney in New York who says, hey, we're doing a probate for Samantha in New York, but she also had a property in Boca. Can you do a probate there for her as well? And now her family's doing 2 probates. So what you'd want to do, your primary, what we're talking about, the trust and everything like that, is going to be prepared usually in the state by an attorney licensed in the state where that person is a resident. So if a person is a resident of Florida, I can do, or an estate planning attorney can do their stuff here in Florida. If they have a second home in North Carolina, Tennessee, wherever, we will do, or we'll have an attorney in that state do a deed and transfer the property in that state to the name of the trust. So even though the property was done, the trust was done in Florida, we can put assets from other states into the trust that's in Florida. And that way, again, if they own a property in Tennessee, the property can be owned by the Stivers Trust, even though Stivers am here in Florida. And that way, my family doesn't have to do 2 probates, or they don't have to do 1 in Tennessee, because the property in Tennessee is owned by the trust. Now, that works for the US state. Other countries, we can't do that. If someone is coming from another country, I can't draft a legal document that's going to say what happens to a property in Argentina. because I don't know. I don't know what the laws are in Argentina, right? Each country has their own unique laws and different things like that. So if someone has a property in another country, we'll do planning for the assets that they have here in Florida or the States, if we can, but they're going to need local counsel, local attorneys for their assets that they have in other states. Another question, who needs to be present at the moment of creating a trust? So who's going to sign it? You're going to have two witnesses. You're going to have the notary, and then whoever's trusted is needs to sign it. Yeah.
So
Well, cool.
basically,
Yeah.
it's none of the heirs or anybody involved, just the person with the assets.
Yeah, correct. And they don't even, the people who are a lot of times, parents will tell me, listen, I don't want to tell my kids exactly. And even if they're leaving it 50-50, maybe there's just a reason, because maybe I'm just making up something. Maybe like the son was really involved with the family, but the daughter was not. But the parents are going to leave it 50-50 to the two kids. And they're afraid the son is going to get upset that the daughter's getting 50%, even though she was never involved. So the parents might say, I don't want my kids to know about this. And that's fine. What my general suggestion will be, you don't have to give them copies of it, but you might want to let them know, hey, I did this. If and when the time comes, this is where I have a copy of it. Or you tell somebody, because, again, if you don't let somebody know, I'm not going to know if I did your trust, I'm not going to know necessarily that you passed away. And so if your kids don't have, know, or someone doesn't know that you had copies of it, then we no one's going to know. So you might want to let somebody know, but you don't have to give necessarily notice to the kid. Yeah. And then last question, I think, and then I gotta jump off here, but can you change a trust after? So while you're alive, it's your trust. You can change it. You can add people. You can remove people. You can do whatever you want. Once you die, that trust cannot be changed, right? So once you pass away, the trust can't be changed. Yeah. So, all right. I see now I say I'm leaving. I see more questions coming in. I got I'll answer these real quick, and then I can't answer. I have to jump off, but I have my information in here, and I'm going to record this, and I'll send it out to you all after. All right. So does the husband need to be present? No. Again, it's just the person whose trust it is. If now most people, well, I won't say most, but the majority of trust, it's a joint family trust. So husband and wife, or whatever the partnership is, it's a joint trust. So it's both of their trusts. So in that case, both have to be present. But I do have clients, for whatever reason, maybe it's second, third marriage, where spouse has one trust, other spouse has another trust. They don't need to be present for each other's signings, just their own ones. And then last one, I think I mentioned this, but you still get the homestead exemption even when you put the property into a trust. So you still get the homestead exemption. So awesome. Well, thank you all. Elizabeth, Lino, thank you all again for having me. I'll send everything to you all, and happy to help any way I can.
Thank you so much, Justin. And you can send all your questions and clients to Justin. He now has a child to put through college. So
we are more open for business than we were before. So yeah, thank you all. Bye.
Hey, Justin, sorry, I was trying to talk.